Running a business comes with a lot of what-ifs. But luckily, there's a simple answer to them. Shopify. It's the commerce platform behind millions of businesses, including Thrive Cosmetics and Momofuku, and it'll help you with everything you need. From website design and marketing to boosting sales and expanding operations, Shopify can get the job done and make your dream a reality. Turn those what-ifs into... Sign up for your $1 per month trial at shopify.com/special offer.
The Red Apple Media Podcast Network presents This is Protecting America. Now, here's Emmy-winning journalist Rita Cosby.
And welcome to another edition of Protecting America. I'm Rita Cosby. Well, some big developments on several important cases surrounding former President Donald Trump, from Georgia to D.C. to New York City and beyond. And joining us now is the great former federal prosecutor and also a superb legal analyst, Doug Burns. Doug, great to have you here.
Thank you so much. Appreciate it.
Big decision this week from the highest court in the land. The U.S. Supreme Court says Colorado cannot kick Trump off the ballot. This was enormous, 9-0. Is that surprising that it was unanimous? That's very rare by the U.S. Supreme Court.
It is rare, and it just shows you that the issue was as obvious as it was. It was a straight legal question, and that's where it started getting confusing. In other words, all of the factual debates, what's the definition of insurrection? Did President Trump engage in it? That had nothing to do with this, quite honestly. This was a legal question, and the legal question was, if anybody wants to disqualify a candidate for the presidency, who does it? Okay? And it was so interesting, Rita, because in Section 3 of the 14th Amendment, it talks about disqualification for insurrection. And I'm chuckling because Section 5 specifically says that Congress shall do it, not the states. And that was, much less widely reported on. And of course, I was, sort of personally thrilled in the sense that, I was explaining calmly over and over in media that it is Congress that would adjudicate that if it came to that. And then there was another finer point on the pencil, very important, and that is that in Section 5, it also says that even if someone were disqualified for insurrection, Congress can override it by a 2/3 vote. And that had some additional significance, because the additional significance was this was premature. You have to wait and see if somebody wins an election. Okay, the prohibition, Rita, was not against running for office. The prohibition is from serving. So I felt, and I saw all the other, many of the other pundits and experts predicting that it was a clear question. I was very pleased to see the liberal wing of the court agree. That was good. It was a good day for law in that sense. And then last, I do have to throw in that it was pretty disgraceful, seriously, and I'm going to use their names, to see Professor Lawrence Tribe of the Harvard Law School. The man is a constitutional law professor, and he completely disingenuously argued that the Colorado Supreme Court decision was correct. I mean, it was disgraceful. And as a Sherlock Holmes, I know full well that he knows that's not true. So that's just a variegation of Trump derangement syndrome. A conservative former federal judge, J. Michael Ludwig, same exact thing, arguing on liberal media that the Colorado decision was correct. He knows better than that. And frankly, he embarrassed himself. So in the end, to sum it up, it was a great decision, 9-0.
Isn't it interesting, Doug Burns, because can you imagine if they said, okay, well, a random Secretary of State who's appointed, who clearly has a political bent because they're appointed a Democrat, then another Democrat. Imagine if they had allowed this to go forward, the chaos it would have created in our country.
Well, that's a slippery slope toward chaos. And you're spot on, because right in the opinion, even though it's really not a technical legal point in terms of interpreting, who would adjudicate this, right in the opinion, which just for everybody following, it was called a per curiam opinion, Latin for by the court. So there weren't, individual opinions by anybody. There were a couple of separate opinions at the end, which were overreacted to by liberal media. So let me just explain that. A couple of the liberal justices said that the court needed only to determine that the states do it, not the feds. And the court went on to delve into how the federal government would do it. And it was really much ado about nothing. But back to your point, critical point, you cannot possibly open the floodgates to have an individual, Democratic Secretary of State do this, because guess what's going to happen? And of course I'm being sarcastic. Then a Republican Secretary of State will kick off a Democrat, and it's a vicious cycle on and on and on. And by the way, little constitutional history, that's precisely why the founding fathers left it up to Congress.
Now you bring it up to Congress because, of course, Democratic Congressman Jamie Raskin, and I think he mentioned Eric Swalwell and Debbie Wasserman Schultz and others. He, of course, you think of him. Whenever I think of him, he was on the January 6th committee. But here he right away, I think it was within almost minutes of the decision from the Supreme Court, said, we may look at legislation in Congress. Explain this and what he is trying to sort of do, this lawfare that he's trying to do.
Well, first, a quick editorial, which is that very often, and I'm chuckling, when you have a decision that you lose on, under being a little bit of a sore loser, you come out right in front of the camera. We are going to address this now, through legislation. I don't think that's going to happen. But to answer your question, look, if the Supreme Court says that Congress has to do it, Congress could do it. There's only one problem. They don't have the votes to do it. If they did, by the way, I think that they would have taken a shot at trying to disqualify him. But that's Raskin. I've criticized him honestly, publicly. He comes out. He's a graduate of Harvard Law School. So to me, that really puts him at a little different standard in terms of arguing things. But he's, more infected by the politics than the law stuff. And so, he's saying that they're going to take some congressional action, but I do not believe that's going to happen.
Now, there's a window, right, where, say, President Trump gets elected and it becomes a Democratic House and a Democratic Senate. There's a lot of ifs there. But if that happens, that's sort of the window I think he's looking at, right, Doug Burns?
No, that's brilliant, because you're right. If, hypothetically, a law school classroom, let's say the House shifted Democratic, that's only step one. Step two, let's assume for the sake of argument that they really had the votes to do it, okay, when it was all said and done. They could ostensibly try to take some action even after he was elected, which was my point originally, which is that's how it's supposed to happen anyway. So Trump wins the election, November 5th. Even, take it a step farther. He could be sworn into office and be president, and they could make him ineligible, by the way.
Right. That's right. There's no time limit, right?
There's no time limit on
but
it.
That's interesting, because then it might be like, oh, my goodness, they're going to keep doing that for how long, right?
Exactly right. So it's really, but again, to be a broken record, it was interesting. What I said was, in some media stuff, I said that, look, it was a good day for American courts. I said, is that because Donald Trump won? No, it has nothing to do with that. It has to do with the fact that 9 justices, using no politics, no ideology, they analyzed the plain meaning of a constitutional amendment, and they analyzed it correctly, and that's the end of it. So the point is, we lawyers, quick digression, have what we call the plain meaning rule. So if the meaning is plain and apparent on the face of a statute, or in this case, a constitutional amendment, then that's it. Section 5, quote, Congress shall be the one to enforce this. Another comical aside, I see a pundit, you're going to love this, on one of the liberal cable networks, and they go, just because it says Congress shall do it, that doesn't mean the states can't do it. That's just idiotic, okay?
That is idiotic. It is obviously stretching everything.
Right, exactly.
This episode is brought to you by Progressive Insurance. Do you ever find yourself playing the budgeting game? Well, with the Name Your Price tool from Progressive, you can find options that fit your budget and potentially lower your bills. Try it at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Not available in all states.
Fellas, you know Degree Cool Rush deodorant, right? Well, last year they changed the formula, and guys were mad about it. One dude even started a petition. So guess what? Degree heard us, admitted they messed up, and brought the original Cool Rush scent back exactly how it was. And it's in Walmart, Target, and other stores now for under $4. So grab some and remember why its cool, crisp, and fresh scent made it the #1 men's antiperspirant for the last decade. Degree Cool Rush is back, and it smells like victory for all of us.
Mic check. 1, 2. Are we recording? Hi, I'm Michelle Bernstein, an award-winning chef, restaurateur, and mom. I have a lot on my plate, including my psoriatic arthritis symptoms. That's why I was prescribed Cosentyx. It helps me move better.
Cosentyx secukinumab is prescribed for people 2 years of age and older with active psoriatic arthritis. Don't use if you're allergic to Cosentyx. Before starting, get checked for tuberculosis. An increased risk of infections and lowered ability to fight them may occur, like tuberculosis or other serious bacterial, fungal, or viral infections. Some were fatal. Tell your doctor if you have an infection or symptoms like fevers, sweats, chills, muscle aches, or cough, had a vaccine or plan to, or if inflammatory bowel disease symptoms develop or worsen. Serious allergic reactions and severe eczema-like skin reactions may occur. Learn more at 1-844-COSENTYX or Cosentyx.com.
Ask your rheumatologist about Cosentyx.
Now, as we know, there's a lot of cases with President Trump. Of course, now we're hearing that the U.S. Supreme Court is going to hear the oral arguments in Trump's immunity case. That's going to be on April 25th. Talk about what you think might happen there. That's if he has the presidential immunity. And of course, that would extend to the D.C. case. It could also cover some of the issues in the classified documents Florida case. Your thoughts about the big issues at heart there?
Well, I think the audience will find it interesting that I said that the Colorado matter was a legal question, which it was. The immunity question is more of a factual question, and here's why. The law of immunity from 30,000 feet is that a president absolutely should have immunity for acts that are within the scope of his presidential duties, okay? And one could argue that he's not entitled to immunity for acts that go outside. Now, naturally, in the toxic political climate, the left argues, of course, this was outside the scope, and the right calmly argues, no, it was within the scope of him being president, and you can debate that any way you want. So what's going to happen, and, I heard this from other experts, and I agree with them, is that the Supreme Court is going to lay down the law that I just explained, and then they're going to turn around and possibly say, we need some further fact-finding, remand it back, as we call it, to the court to find out whether they feel that the actions that he took were within or outside the scope. But also, you have to look at the chronology thing. I feel like a broken record, but it behooves me to repeat that the government doesn't ask for speedy trials. You and I have discussed this. I've heard you discuss it. The speedy trial right is a defendant's right, and the government never really cares much about going to trial quickly, okay? They go to trial in the ordinary course. Here, we see this comical hysteria about getting these cases to trial, and back to my Lawrence tribe and, Mike Ludwig stuff, and you've got legal, quote-unquote, experts on liberal cable saying it's very important to the government that there be a speedy trial. That's complete hogwash, okay? As I just said, the government doesn't really assert speedy trial rights, and it's another kind of hysterical scam. Maybe that's a little bit of a harsh word, but it really is, because the point is there's no need for these cases to be rushed. And as we've all pointed out calmly, these cases could have been brought 2 years ago, Rita.
Yeah, they could have, but now it's convenient because it's election time. How are they not all examples of election interference?
They're all absolutely examples of election interference. Everybody's saying the quiet part out loud. I have friends of mine, law school graduates and so forth. Admittedly, they don't practice in the criminal law area, which is important, seriously, because they really don't know what they're talking about. And they just glibly and calmly tell, oh, no, it is important that the case go to trial quickly. And that's just complete hogwash. And it's embarrassing. The question that I have, which is interesting, and nobody seems to really want to get into it because it's down the road, but if Trump, either way, wins or loses, follow me, I think there'll be zero interest in any of those cases.
Right. It's only because of the timing right now.
And that will give it away. Some of my friends actually taking fairly a smart tack on it, say, no, they're going to have to make it like they care about it, because otherwise it shows that it just simply was to interfere with the election. I think the jury's out on that. But I'll tell you what, I'm concerned about this Alvin Bragg case, Rita.
Yes. So where do you think that case? That's the New York City case. It's a criminal case. And what's interesting, Doug Burns, that's going to start soon, obviously. And that is also, that's about the Stormy Daniels, whether it was an inappropriate business entry versus campaign contribution. It's the first time in American history that a former president will be at a criminal trial, will be the defendant there in a criminal trial. Is this the one that you want to say it's history making over this issue?
It's a split discussion, because on the merits of the case, you've heard all the experts say, incredibly weak case. You and I have discussed it. It's a misdemeanor case on its best day. A lot of it was out of time, barred by the statute of limitations. I told you that I read that book by Mark Pomerantz. In there, he admits that really the only way to bump it up to a felony is through another New York State crime, whereas their theory was that it was a federal election crime. You mentioned election a minute ago. And so the point is, it's just beyond a weak case. However, when you see the E. Jean Carroll result, from 30 years ago, no details remembered, et cetera, and a hysterical $83 million judgment. And when you see the Angaran, Letitia James matter, not to rehash that, but no loss, no victims, banks satisfied, banks come into court and say we would do business with them again, we were paid back, and he gets tagged with $350 million. The point I'm trying to make is that this is just a complete outlier venue, outlier court for him to be in. And I'm concerned that regardless of what the evidence is, he's going to get convicted. I'm very concerned about that.
Yeah, it's interesting because it is New York. And just like you said, look at what's already happened to him in New York. You never, ever know. Before I let you go, Doug Burns, I got to get into also the Fani Willis case, because more fireworks this week. And oh, my goodness, new information coming out from Ashley Merchant. She's, of course, the attorney for one of the defendants in the case, because there's many of them, not just Trump. It's the RICO case in Georgia. And she also presented logs from the White House. These are the visitor security logs. And they show, one of the things I thought was the biggest bombshell is she shows a meeting that Fani Willis actually goes to the White House to meet with the Vice President, Kamala Harris. That sounds very fishy. Isn't that collusion?
Well, this thing has just gotten worse and worse and worse for Fani Willis and Wade. They were very, very arrogant when they were in court. They should have said, look, it was a personal relationship. It's none of anybody's business. And yes, it did start back in 2019. It's hard to do that, admittedly. But one thing I've learned in 38 years in criminal law is when you make something 10 times worse, you say to yourself, wow, I wish I did what Mr. Burns just said I should do. Because here they went in, they were completely and totally untruthful. Any trier of fact in any situation I've ever seen in 38 years knows full well that the relationship started. And by the way, lest there be any confusion, the lawyer, he was testifying that he didn't remember anything. There was a text message to him, quote, did this relationship start before she hired him? Answer, absolutely. And then they even got specific. They said it was when she left the DA's office and became a judge. He wrote that. That's 2019. So they made it 10 times worse, step one of horror, by lying about when it started. Then it gets 10 times worse because Nathan Wade went to the White House a couple times, Rita, which is unreal.
Yeah, 2 8-hour meetings.
Exactly. Although the way he bills, and I'm being semi-sarcastic, maybe it wasn't an 8-hour meeting, right? I never tell jokes, but here we go. A lawyer dies. He goes up to heaven and he says, I can't believe I'm here. I'm only 47 years old. And the guy at the pearly gate said, well, according to your legal billing sheets, you're 91.
And that might fit Nathan Wade, his style of billing.
No, but to your point, and now you have Fani Willis, and I wasn't as familiar with this. I heard it a little bit by osmosis today, meeting with Kamala Harris. This is getting worse and worse and worse. And one anchor asked me, look, don't you think maybe she might just cut her losses and step aside? I think that's possible, Rita.
Do you think so? Because she seems, I use the word sort of defiant. You talked about when she was on the trial, she was pointing the finger at the judge. The other thing I wonder, too, and you talked about how, like, New York City obviously has not been favorable to Trump and the juries. The judge in the Fani Willis case, he seemed to be reining in the other guy, Terrence Bradley, who was the one who was in the text messages that you're talking about with Ashley Merchant. But then when Fani Willis was on the stand, she seemed like she was ruling the courtroom. It almost seemed like that judge was afraid of her because they're in the same jurisdiction. Is there a chance that after all the things that we see, Doug, and that I think most people see out there, that who knows what this judge in Georgia has to deal with Fani Willis and all his colleagues, who knows what he'll do, right?
No, but very insightful, obviously, from a long-time legal journalist. The point is, of course, you've got all kinds of dynamics down there. I was in the U.S. Attorney's Office, as you well know, and the relationship between the United States Attorney himself and the various judges. I mean, this is part of day-to-day life. So that's absolutely a factor. But this judge, in fairness, the good news is seems quite solid. The bad news hasn't been a judge all that long. But the fact of the matter is I can't really predict with certainty what he's going to do here, seriously, because of the exact thing you just laid out, seriously, which is the relationships. They have to function every day, all day together. That's what, a criminal courthouse is quite an amazing place. Everybody's got their roles, the defense lawyer, the judge, the court reporters, all working in unison like a synchronized, machine. So I'm not so sure he's going to kick her off the case. We'll see. But back to my point a minute ago, this is continuing to just get worse and worse for them. And at some point they should consider cutting their losses.
If he does decide to dismiss them, or if they remove themselves, say she and Nathan Wade remove themselves, what happens to the case? Is there a good chance that at minimum it's delayed, or is it possible that it could just fall apart, that another prosecutor is like, oh boy, what a hot potato?
Well, it was fascinating, again, to see some people in the liberal cable world saying the quiet part out loud, Rita. It was fascinating. And they're like, but if another prosecutor comes in, my goodness, they may look at this and decide not to go forward. Yeah, well, hello, exactly. That's the whole point, which is that on many levels, this particular prosecutor is an outlier, like Letitia James, like Judge Angoran, with a political agenda, a political axe to grind, trying to play to a constituency and a Democratic, clubhouse, so to speak. And so the fact of the matter is, to your point, spot on. Yeah, another prosecutor may very well walk away from this whole big mess.
Yeah, he may just say, forget it, or he may say there's nothing here. I mean, the case is so tainted now, don't you think, Doug, regardless?
Well, it's tainted, number one, exactly. Number two, the optics of, this was supposed to be the knight in shining armor, even from the perspective of the left. Hear me out. That's our knight in shining armor. She's amazing. She's going to take down the evil, horrible Trump. And then look at her conduct. It's completely embarrassing. It gives great shame to the whole notion of, fair justice and so on, conflict of interest, appearances of impropriety. Amazing. Hang another editorial to watch the left side media, bend over backwards with a straight face. No, I don't really think there's a conflict. And, oh, no, it's not appearance. It has to be an actual conflict. I mean, these people don't quit, to put it in simple English. The fact of the matter is that the type of behavior you want to see from the lead law enforcement officer in your county? No, of course not. So, again, we'll see what happens. But I think that there's a lot of taint in the case. I think there's a lot of irony in it, and it kind of irony in the sense that it shows that a lot of these crusaders really are highly, highly politically motivated. Okay. Alvin Bragg, Letitia James, Fani Willis, just on and on and on.
Doug Burns, you are terrific. And listen, everybody, be sure to subscribe and share to this very powerful podcast. Former federal prosecutor Doug Burns, you have such great analysis, and I love you walking us through all of these important cases. Thanks so much, Doug.
My pleasure. Thanks for having me.
And everybody, I'll be back soon with another great edition of Protecting America. And of course, you can catch me every weeknight, 10 p.m. to midnight on the legendary WABC Radio. This is Rita Cosby, and thanks for all you do to protect America.